towards the end of my comments, I mean, that's deep, right? That's saying maybe there's some Jewish influence, but it's at a really level of deep intellectual historical roots. If we're looking for less deep, more immediate manifestations of contemporary influence of Jewish culture, Jewish law on American law, and whether the Kiryas Joel cases exhibit any such thing, I think if the question is sort of the very narrow sociological one, are the Jews who've been involved in the Kiryas Joel litigation, and interestingly, another interesting story to tell, Jews are heavily involved on both sides of these cases, the Supreme Court case as well, have they had an impact? Has Kiryas Joel itself in any really significant way reshaped American law? I would say no. I don't think any of these cases change the face of American law. On the other hand, I think there's a big, long, complicated, interesting story to tell, and I think it's sort of been illustrated in this room more and more so about how Jews in the 20th and 21st century have participated in broader cultural trends that have greatly affected the shape of contemporary legal doctrine, in particular, but not only constitutional doctrines pertaining to the Free Exercise Clause, Establishment Clause. And that's another long, complicated story to tell. That's not a deep intellectual history one, it's a sociological one. But I'm referring precisely to the divisions of opinion that we've just seen played out between Mark and Nathan, and yesterday between rift. I mean, we could put it very simply, between an Orthodox Jewish take on the proper interpretation and one might even say the more traditional American Jewish position on all of these issues. Both sides of that debate are clearly participating in larger trends, right? We all know that the Orthodox position is allied with positions taken by conservative Christians, and vice versa. There's an alliance between Jews who adhere to the liberal secularist ideal and liberal Christians and people who identify themselves in no religious terms at all. There are many, many causes, and I think Mark hinted at some very interesting ones. I just want to, in closing, throw out one additional possible cause. When I think about this from the standpoint of the deep intellectual history story that I would be interested in telling someday, time permitting, I think one could say the following thing. The thing about the theory of imperfect law, theological secularism, secularist theology, whatever you want to call it, is that it's a synthesis of religion and secularism. It's a religious argument for secularism. It's a secularist ideal with religious roots. I think one of the things we're seeing happening, and that partly explains the content of the division that we've just seen, is that you're seeing the synthesis of religion and secularism fall apart. I'm just going to summarize what I mean. But the secularization, one of the things you see is that the originally religious idea of secular law has been secularized, and on the other hand, the religious conception of the political has been desecularized. The result is the idea of the secular loses its religious grounding. At the same time, religious traditionalists, Jewish, Christian, whatever, lose touch with the traditional religious arguments in support of the need for secular law. And I think that's part of what fuels this process of polarization, which we've seen ample evidence of in this very own, in the very place where we're sitting today. So I will leave it at that and leave my comments about privatization for another day.